Josh, I've been looking at the order deeming this defendant competent by the judge to kind of get a sense of what this judge thinks about the case. And he noted that this defendant has an IQ of 97, that he seemed to be able to answer all of the questions appropriately from the doctor. There was one doctor that said he's not competent, one that said he was, and the judge decided that he was not competent to stand trial. Your thoughts on how that may weigh into what we see for sentencing?
I think that'll be a huge factor, because you have to understand competency to stand trial is a much lower standard than even, we hear discussions about a person who pleads not guilty by reason of insanity. And we understand that insanity in a criminal sense has to do with somebody's appreciation of their actions and understanding between right and wrong. Competency is even lower than that. People can be competent to stand trial and still plead not guilty by reason of insanity. We see it all the time. Competency just says that you have a basic understanding of what's going on, the process, who your attorney is, who the judge is, what everyone's role is, what you're on trial for. Very basic things. And so for a judge to call into question even his competency, I think is going to play a huge factor in whether or not and how he sentences this young man, because it sounds like these mental deficiencies and issues, the disabilities that he was dealing with played such a huge role that even the judge felt that he couldn't stand trial.
Oh, well, I hope I didn't misspeak, Josh. The judge found him competent to stand trial.
Oh, pardon me.
Identified that his IQ was very high, that he was intelligent. So it seems that this judge perhaps, but to your point, this was not an asking of whether or not he was insane and could not appreciate the wrongfulness of his actions. They didn't even get to that point, because after this competency evaluation and the judge saying, yes, he's competent to stand trial, the plea started to happen. Are you surprised that they decided to go the plea route after that order and not continue to push with the plea of not guilty by reason of insanity?
This is one of those situations where, the whole crime is caught on videotape. It's brutal. It's awful to watch. Putting this in front of a jury is going to be very, very difficult. I think they probably understand that their arguments are a little more nuanced. Their arguments are a little more legal. They're asking for mercy from the judge. This would be the judge that would sentence after a conviction at trial anyways. So I think they're saying, listen, we're not dealing with a young man here who's trying to fight this crime, who's trying to say that he's not guilty of the actions that he's caught on videotape doing. We're saying that there are extenuating, mitigating circumstances outside of that event and that day that the judge should consider. And so it's understandable that they would go straight to a sentencing hearing and just ask the judge for mercy, essentially.